judgment in the appeal in the matter of A, a child.
Lady Hale will give the judgment.
A is a little girl of 10, whose parents separated when she was a baby. An order was made that she should stay with her father when he was visiting from abroad. X is a vulnerable young woman who has alleged that the father seriously sexually abused her when she was a child. The local authority found her allegations capable of belief and advised the mother to take steps to protect A. So the mother applied to vary the contact order to ensure that contact between A and her father was supervised. The court and the parties, of course, wanted to know who X was and to see the local authority's records of her allegations. But the local authority resisted this because of the harm which disclosure would do to the fragile physical and mental health of X. There is medical evidence that she suffers from a physical condition which has at times deteriorated to the point of being life-threatening because of stress. The trial judge refused to order disclosure, mainly because this would lead to X having to give evidence, which would cause her so much harm as to amount to inhuman or degrading treatment. The child's guardian appealed to the Court of Appeal, which allowed the appeal and ordered disclosure. X appeals to this court, which unanimously upholds the order of the Court of Appeal. The local authority's records of X and her allegations are subject to public interest immunity because of the public interest in encouraging people to come forward to help the authorities to protect children from harm. But this immunity has to be balanced against the public interest in a fair trial. The court is not normally allowed to take into account material which has not been disclosed to all the parties, so the choice is normally between disclosing the material or ignoring it altogether. Very exceptionally, a court deciding upon the future of a child may take into account material which has not been disclosed to all the parties, but only if disclosure will cause harm to that child. Since the Human Rights Act, this possibility may be extended to protect third parties such as X if disclosure would violate their convention rights. In this case, neither the trial judge nor the Court of Appeal, who had seen all the material and the detailed medical report on X, considered that disclosure alone would not cause such severe harm to X as to amount to the inhuman or degrading treatment prohibited by Article 3 of the European Convention on Human Rights. Disclosure would interfere with her right to respect for her private life, protected by Article 8 of the Convention, but non-disclosure would potentially expose A to the risk of serious harm and interfere with the right to respect for their family lives of A, her mother, and her father. It would also violate their rights to a fair trial, protected by Article 6. For everyone's sake, the court needs to be able to decide upon the truth of the allegations and whether A is at risk of harm from her father. It cannot do this fairly without the allegations being revealed to the parties so that they can be properly investigated and tested. It does not follow that X will inevitably be called to give evidence in the usual way. If she is unfit to do so, there are many other ways open to the family court to receive and test her allegations. The concern of the court is to get at the truth for the sake of A and her parents, and to do its best to avoid harming X in the process. I should make it clear that the X in this case is not the same person as the X in the case in which we previously gave judgment.